The hearing will come to order. Without objection, the chair is authorized to declare a recess at any time. Today is the third panel of the Oversight and Investigations Subcommittee hearing entitled Learning from VA Whistleblowers. On June 25th, the subcommittee began this hearing to discuss the importance of VA whistleblowers. We heard testimony from people inside the VA who raised major questions and concerns about critical problems that affect the health and well-being of veterans. These witnesses were willing to blow the whistle even when it risked their livelihood and their careers. Unfortunately, we learned that the VA continues to struggle with the culture of retaliation against whistleblowers. In too many instances, VA leadership and supervisors have turned a blind eye to those in VA's workforce that have pointed out serious problems or attempted to expose bad actors who have abused their positions or broken laws. And even worse, the whistleblowers are often the target of active retaliation. One striking example came from Dr. Catherine Mitchell's testimony. In 2014, she was one of a group of people working at the Phoenix VA Medical Center that exposed the existence of a secret waiting list of veterans in need of medical care. Instead of addressing this issue, the Phoenix VA leadership actively worked to hide the exorbitant wait times. And it turned out that such practices were occurring at VA facilities nationwide. The cover-up was extensive and deliberate, and the health and well-being of veterans was put at risk. Congress responded to the allegations with hearings that confirmed the whistleblowers' revelations of long and difficult wait times for appointments. Of course, the VA still has a lot of work to do to ensure that veterans get access to health care in a timely and transparent manner. In fact, the Committee on Veterans Affairs will hold a hearing on this very topic tomorrow. The Phoenix VA employees, including Dr. Mitchell, who blew the whistle in 2014, raised incredibly important concerns regarding veterans' health care. Instead of being thanked for raising these issues, however, they've experienced retaliation. Their jobs were threatened, and they faced a hostile work environment. Unfortunately, their experience is not uncommon. Our two other witnesses during the June hearing also testified about retaliation they're experiencing, all while continuing to work at the VA, and they've sought protection as whistleblowers. The June witnesses described many shortcomings within the VA for protecting the rights of whistleblowers. Each of these three individuals who testified described ongoing retaliation that they were experiencing despite current laws and institutions designed for their protection as they try to speak truth to power. For example, Dr. Mitchell testified that retaliation is ongoing even after she secured a settlement agreement with the VA to continue her work serving veterans. Clearly, the VA must do better. Make no mistake, this committee believes the importance of having people who are brave enough to stand up and blow the whistle on the missteps and misdeeds within the department. These are people who are trying to do the best they can for veterans, and we should be committed to their protection. At the beginning of the June 25th hearing, Ranking Member Bergman requested that we invite representatives of the VA and other government agencies to testify before this subcommittee. I agree that the government agency perspective is essential. In fact, the subcommittee will hold an additional hearing with government witnesses in September. It's been 2 years since Congress and VA established the Office of Accountability and Whistleblower Protection. Our September hearing will focus on the results of an Inspector General's investigation of this particular office. Today's panel is an early opportunity to hear from VA's Office of Accountability and Whistleblower Protection. In addition, the top officials from the Office of Inspector General, the Office of Special Counsel, and the Merit Systems Protection Board are present. Each represents a key agency charged with protecting whistleblowers. I've also invited two of the whistleblower advocates who appeared on the June 25th panel to ensure a strong and important dialogue with today's government officials. As I've said before, and it needs to be repeated again, whistleblowers are an important source of information, and they should not be ignored. Their rights must be protected so that future whistleblowers will have confidence that their stories will be heard and assurance that their allegations will be investigated without reprisal. I look forward to the testimony of today's witnesses, and with that, I'd like to recognize Ranking Member Bergman for 5 minutes for opening remarks.
Thank you, Mr. Chairman. I appreciate your holding the hearing open to allow us to receive testimony from government witnesses who administer the whistleblower programs. Scheduling a hearing this quickly is difficult, and I appreciate you following through on your commitment to hold this hearing as soon as possible. The first witness panel recounted case-specific complaints, but we had little discussion about the whistleblower process. The discussion bounced back and forth between complaints with VA's Office of Accountability and Whistleblower Protection, or OAWP, the Office of Special Counsel, or OSC, and the VA Inspector General. Witnesses also raised concerns that the current lack of Merit Systems Protection board members clouded its operations. It is critical that we understand the division of labor in the whistleblower protection system if we are going to diagnose the problems and craft appropriate solutions. Let me give you an analogy in my pilot background. There are 4 forces that affect an airplane's ability to fly: thrust, weight, drag, and lift. When a problem arises, that pilot must understand which force is being affected because the response will differ depending on the nature of the problem. The whistleblower process is no different. The remedy for a disclosure problem may be vastly different than a retaliation problem. I want to make sure that we have the right framework and identify the appropriate accountable parties to address whistleblower concerns. Behind me is a diagram of what I understand to be the whistleblower reporting process for VA employees. When we discuss whistleblowers, we must distinguish between disclosures and retaliation, because when an employee is alleging what an employee is alleging and where they go for help depends on whether they are making a disclosure or a retaliation claim. A disclosure is the initial blowing of the whistle. It is when an employee brings the attention to the $600 hammer, secret wait lists, or potential criminal activity. Retaliation, on the other hand, is what happens after a whistleblower makes a disclosure and experiences an adverse impact on their work or career because of their disclosure. Retaliation may occur when management proposes to remove the employee or move them to an isolated office without heat or air conditioning. It might manifest in the form of multiple investigations or a threat. A whistleblower can make a disclosure to their supervisor, OAWP, the VAIG, or the OSC. In fact, a whistleblower may make the same disclosure to all of these offices, and it is unclear what type of communication exists between the parallel routes for investigation. Similarly, a whistleblower may raise a retaliation complaint to OAWP, OSC, or the MSPB. Again, a whistleblower can raise his or her claim in multiple forums, and it could lead to multiple investigations. Mr. Detbarn described the process of seeking whistleblower assistance as confounding, and the other witnesses echoed that sentiment. In the Marines, we employ the KISS principle, just keep it simple, but the whistleblower process depicted in this diagram runs afoul of that principle. This is another example of Bureaucracy 101, a government program with multiple governing offices and diffused responsibility which, together, create confusion and a lack of accountability. Our witnesses are undoubtedly the experts on what works and what needs to be improved in the whistleblower protection system. I would like each of you to explain your office's role as it relates to disclosure or a retaliation claim. A common grievance is the lack of communication between the investigating officer and the whistleblower following a disclosure or retaliation complaint. I would like the witnesses to explain what an employee should expect from the investigator in your office, what barriers exist to timely and thorough communication, and what steps you are taking to improve this communication. Mr. Chairman, before I yield, I want to reiterate that whistleblowers provide an invaluable service to our country. They must believe that the whistleblowing systems take their concerns seriously and investigates their complaints appropriately and efficiently. More importantly, or most importantly, whistleblowers must feel safe to make a disclosure. It is evident that the witnesses on the first panel do not have faith in the system. But I was surprised to learn in the written testimony submitted for today that in FY 2018, the VAIG received 35,000 hotline complaints, that whistleblowers contacted OAWP 1,965 times, and that OSC received roughly 2,100 VA-related disclosure and retaliation complaints. This data suggests that many employees are not afraid to raise concerns. But this is not cause to celebrate just yet, because, as the prior testimony made clear, problems remain, and there is a lack of faith by many in the system. I hope that with a multifaceted understanding of the process, we can identify the root causes of the problems and make a whistleblower system that works better for everyone. And Again, Mr. Chairman, I appreciate you reconvening this important hearing, and I yield back.
Well, thank you, Ranking Member Bergman, and I very much appreciate your recommendation to hold this session today. In appearing before us today are 4 witnesses selected by Ranking Member Bergman to offer testimony, and I'd like to recognize them first, starting with Dr. Tamara Bonzanto. She's the Assistant Secretary for the Office of Accountability and Whistleblower Protection. The subcommittee thanks you for appearing today, Dr. Bonzanto, and you have 5 minutes for your testimony.
Chairman Pappas, Ranking Member Bergman, and members of the subcommittee, thank you for the opportunity to testify today regarding whistleblower protection at the Department of Veterans Affairs. Protecting whistleblowers from retaliation is a priority for the VA and the Office of Accountability. To protect whistleblowers, OAWP directly investigates all whistleblower retaliation allegations made by employees and applicants for employment against VA supervisors. This mitigates the possibility that whistleblowers may face retaliation for making a lawful disclosure. Since my confirmation as the first Assistant Secretary, OAWP has engaged with other federal agencies, including the Office of Special Counsel, the Department of Defense, the Department of Justice, the Department of Labor, and the Department of Homeland Security to obtain best practices to investigate disclosures and protect whistleblowers. OAWP has also developed a process to regularly update whistleblowers who make a disclosure to OAWP about the status of their investigation into their allegations. The Secretary and I recognize the need for improvements to whistleblower protection within the VA. OAWP is actively working to implement several initiatives that will better protect whistleblowers, and I appreciate the opportunity today to address a few of them. We are currently working on standardizing investigator training to ensure that all our investigators understand the law, including whistleblower protections, and can apply it in their investigations consistently. We are finalizing written policy on how OAWP investigates the disclosures it receives. The policy is undergoing concurrence within VA, and anticipate it will be issued before October 1st, 2019. We are also engaged and collaborating with VA's Office of Inspector General and OSC to finalize training for all VA employees as required by the Accountability Act. The training addresses methods for making a whistleblower disclosure, prohibitions against taking action against an employee for making a lawful disclosure, and penalties for whistleblower retaliation. The training should be available later in the fall. In addition to continuously improving whistleblower protection, OAWP is actively working on complying with other requirements of our authorizing statute, including standing up a division to fulfill our requirement to record, track, review, and confirm VA's implementation of recommendations from audits and investigations conducted by the Government Accountability Office, the Office of Inspector General, VA's Office of Medical Inspector, and the Office of Special Counsel. Since my appointment, I've met with several internal and external stakeholders, including VA's HR staff, supervisors, VA leaders, veteran service organizations, and nonprofits such as Whistleblowers of America. I value the input that I receive and look forward to continuing to discuss ways to improve whistleblower protection with all stakeholders. As a veteran, a registered nurse, former investigator on this subcommittee, and now the Assistant Secretary for OAWP, I understand that whistleblowers have a critical role in stopping misconduct within the organization. The Secretary and I value all VA employees and whistleblowers and their commitment to improving care and services for our veterans. I want VA to be a place where an employee can trust that his or her management will take allegations of retaliation or wrongdoing seriously, encourage staff to raise concerns, and not retaliate against staff who raise those concerns. Mr. Chairman, we look forward to working with this committee and our internal and external stakeholders to identify opportunities and best practices to enhance VA's ability to protect whistleblowers. This concludes my testimony, and I'm prepared to respond to any questions you may have.
Thank you very much, Dr. Bonzanto. I'd now like to recognize the Inspector General at the Department of Veterans Affairs, Mr. Michael Missel.
Chairman Pappas, Ranking Member Bergman, and members of the subcommittee, I appreciate the opportunity to discuss the importance of whistleblowers to the Office of Inspector General. We treat all complainants as whistleblowers. That is, we provide the same protections, respond with respect, carefully evaluate their concerns, and safeguard confidentiality. The OIG relies heavily on allegations, complaints, and information from VA employees, veterans and their families, Congress, and the public when deciding where to focus our resources. There are countless examples of how whistleblowers and other complainants have driven change, not only for the matter under review, but frequently at the systems level through changes in policies, practices, and personnel. An individual's decision to bring allegations forward should not have to be weighed against possible adverse actions. The Whistleblower Protection Act prohibits reprisal against public employees, former employees, or applicants for employment for reporting a violation of law, rule, or regulation. That prohibition extends to reports of gross mismanagement and waste of funds, abuse of authority, or a substantial and specific danger to public health or safety. The OIG operates a hotline that is staffed by a dedicated team to receive whistleblower complaints and other information. Our hotline received over 35,000 contacts in fiscal year 18 and over 15,000 contacts for the first 6 months of fiscal year 19. Every contact is reviewed, processed, and acknowledged by an analyst upon receipt. We receive information via telephone, fax, regular mail, and through a web submission form on our website. In addition, there are also posters in VA facilities on how to contact the OIG. As a result of our site visits and other engagements with stakeholders, OIG staff may also be contacted by individuals directly with information or allegations of wrongdoing. The OIG interacts with other oversight entities to ensure that all available resources and protections are available to complainants. There are many agencies that complainants can go to for redress. The OIG's website includes frequently asked questions related to hotline inquiries that outline the types of complaints that are addressed by the OIG and other offices. It also provides contact information for those entities. This information is further provided to individuals who call or write the OIG hotline. Although the OIG advises individuals contacting our hotline how to reach many agencies with the authority to provide relief, we have formalized the exchange of information, particularly for allegations of retaliation. The OIG directs those complainants to the VA Office of Accountability and Whistleblower Protection and to the Office of Special Counsel. As part of our continuous efforts to improve our responses and further our relationship with whistleblowers, I will be delivering the keynote address at the annual Hotline Worldwide Outreach Conference, which honors whistleblowers on National Whistleblower Appreciation Day this July 30th. This conference, sponsored by the Department of Defense OIG, analyzes best practices, discusses lessons learned, and provides examples of the challenges facing the hotline oversight community. In addition, we recognize that some VA employees and contractors may be confused about when it is appropriate to contact the OIG about fraud, waste, and abuse in VA's programs and operations. To that end, we have requested that VA share with all employees an email on National Whistleblower Appreciation Day that has information on how and when to contact the OIG. We are also working with VA to offer more formal training on the OIG and the various avenues for redress available to those with complaints. The OIG values whistleblowers and the information they provide as we explore areas for potential oversight of VA. It is incumbent upon VA stakeholders to protect whistleblowers from retaliation and foster an environment where no one fears the consequences of reporting problems or ideas for potential improvement. I encourage all whistleblowers to contact us with their concerns, and we will treat them with respect, dignity, and in confidence to the greatest extent possible. Mr. Chairman, this concludes my statement, and I would be happy to answer any questions that you or other members of the subcommittee may have.
Thank you, Mr. Missel. I'll now recognize our third witness, Mr. Henry Kerner. He's the special counsel. And Mr. Kerner, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Good evening, Chairman Pappas, Ranking Member Bergman, esteemed members of the committee. Thank you for holding this important hearing. OSC is deeply committed to veterans, and I'm honored to be here to discuss the ways in which OSC can assist the VA in providing the best possible service to veterans. Whistleblowers are vital to ensuring that problems within an organization are identified and fixed. OSC's contribution to this process is twofold. First, OSC provides a safe channel for VA employees, applicants for employment, and former employees to make disclosures of wrongdoing. And OSC has the authority to demand a full investigation of any disclosures that warrant one. Second, OSC works to ensure that VA whistleblowers do not face retaliation. We seek corrective and disciplinary action where we can establish retaliation, and we work with VA leadership to train VA management employees on prohibited personnel practices. We are committed to helping the VA by ensuring that those patriotic employees who have devoted their professional lives to serving veterans, some being veterans themselves, can do their jobs without fear of reprisal. Like you, I watched with significant concern as brave whistleblowers came forward at your hearing last month to describe their ordeals at the hands of VA management. I have submitted a longer statement laying out OSC's processes and procedures in detail, but thought I would focus my brief oral remarks on chronicling some of the efforts I have undertaken in support of our veterans and whistleblowers. Our commitment to whistleblowers is manifested in our external outreach to VA leadership and through internal process enhancements. I met with the leadership of the VA as soon as I became the head of OSC, first with then-Secretary Shulkin in November 2017, and later with Secretary Wilkie in August 2018, a short time after his confirmation. I've also had several constructive discussions with the General Counsel and now Acting Deputy Secretary, Mr. Jim Byrne, who's also an OSC alumnus, and with Dr. Bonzanto at OAWP. I've also met Mr. Missel. In all these meetings, I explained my fierce commitment to supporting whistleblowers and preventing retaliation, and I have found each and every one of these VA leaders supportive. While it is clear that more needs to be done to stem whistleblower reprisals at the VA, I take these leaders at their word and count on them to assist us by improving the culture at their department. Internally, the cornerstone of my leadership at OSC involves what I call old-style customer service. That means providing whistleblowers accurate information as quickly as possible, even or perhaps especially if it turns out we are unable to assist them. I am keenly aware of the criticism that OSC can take too long to process cases, which is why one of my very first managerial decisions was the creation of an efficiency and effectiveness working group. Following its recommendations, I undertook a major reorganization of OSC by merging two of our units into one. As a result of these new internal processes, OSC has been much more efficient at assigning cases to attorneys and closing cases where OSC may not have jurisdiction. OSC staff attorneys have forwarded me emails from complainants grateful to have received an introductory email within the first week of filing with us. Of course, we still face a nearly 2,600 case backlog, and it will come as no surprise to you to learn that we do need more funding to be able to reduce this backlog and provide faster processing times to whistleblowers. But despite this backlog, we strive to be as responsive as possible. OSC is part of a mosaic of whistleblower resources available to VA employees, which includes the Office of Accountability and Whistleblower Protection, OAWP, the VA Inspector General, and the MSPB. As an independent agency, OSC offers a distinct advantage and delivers benefits that only we can provide. Part of that advantage lies in the world of disclosing wrongdoing, where the whistleblower is afforded the opportunity to directly participate in OSC's assessment of the agency's investigation of their allegations by providing comments to OSC. And those comments and the report itself are then made public. This is a feature unique to OSC, and whistleblower comments are crucial to my final evaluation of the sufficiency and reasonableness of the agency's investigation. On the retaliation side, OSC offers unique enforcement authority with our ability to litigate corrective and disciplinary actions before the MSPB, taking the decision of whether to correct the retaliation out of the hands of agency management. Together, these OSC-specific features allow OSC to stand out in the field of whistleblower-related entities. Thank you for holding these hearings, and I look forward to answering your questions.
Thank you, Mr. Kerner. Next, I'd like to recognize our fourth witness, Mr. Tristan Levitt. He's the General Counsel of the Merit Systems Protection Board. Mr. Levitt is the most senior official currently serving the board as Acting Chief Executive and Administrative Officer. Mr. Levitt, you're recognized for 5 minutes.
Good evening, Chairman Pappas, Ranking Member Bergman, and members of the subcommittee. My name is Tristan Levitt, and I'm the General Counsel of the Merit Systems Protection Board. Because there are no Senate-confirmed members of the board, I'm also serving as the Acting Chief Executive and Administrative Officer of the agency, as the Chairman said. Thank you very much for this opportunity to testify. As requested, my testimony will focus broadly on the process by which whistleblower cases are brought before the MSPB and adjudicated. This year happens to mark the 40th anniversary of the MSPB opening its doors following the passage of the Civil Service Reform Act of 1978. This law was the first statute prohibiting retaliation for employees of the federal government. It opened with a series of findings stating, "It is the policy of the United States that merit system principles should be expressly stated to furnish guidance to federal agencies, and prohibited personnel practices should be statutorily defined to enable federal employees to avoid conduct which undermines the merit system principles and the integrity of the merit system." The Civil Service Reform Act explicitly recognized the value of whistleblowers. The Ninth Merit System Principle states employees should be protected against reprisal for lawful disclosures. The MSPB was established to fill an adjudicatory role that had previously been filled by the Civil Service Commission. Its role in whistleblower cases is to provide a full and fair opportunity for both parties to develop a record on the issues, and then to hear and decide the matters appealed based on the evidence submitted and in accordance with applicable statutes and case law. As someone who previously received many allegations of executive branch whistleblower retaliation when I worked on Capitol Hill, I recognize that this mission, as established by Congress, is critical in helping distinguish which reprisal claims are meritorious. The prohibited personnel practices related to retaliation prohibit reprisal based on different types of protected activity. Under the statute, in order to receive corrective action in a whistleblower retaliation claim, the appellant must demonstrate that he or she made a protected disclosure, the agency has taken or threatened to take a personnel action against him or her, and his or her protected disclosure was a contributing factor in the personnel action. Even after a finding that a protected disclosure was a contributing factor in the personnel action, corrective action is not granted under the law if the agency demonstrates by clear and convincing evidence that it would have taken the same personnel action in the absence of the disclosure. The MSPB is the forum before which OSC litigates if they believe a prohibited personnel practice like whistleblower retaliation occurred. Outside of cases brought by OSC, the MSPB hears two types of whistleblower cases. The first type of case is called an otherwise appealable action. This involves an adverse personnel action that is directly appealable to the board, such as a removal, reduction in grade or pay, or suspension of more than 14 days. In such an appeal, both the appealable matter and the claim of reprisal for whistleblowing will be reviewed by the MSPB. The claim of whistleblower retaliation is termed an affirmative defense. That is, if the agency proves that it has met the evidentiary standard for taking the action, the appellant may attempt to prove that the agency nevertheless took the action in reprisal for his or her protected whistleblowing activity. The second type of whistleblower case is those cases in which the individual has filed a complaint with OSC, but OSC has not sought corrective action on the individual's behalf. This is called an individual right of action, or IRA appeal. Most of those cases surround personnel actions that are not directly appealable to the board. For example, a suspension under 14 days, or a reassignment with no reduction in pay or grade. In such circumstances, the appellant is required to exhaust the administrative remedy of first filing a complaint with OSC. In an IRA appeal, the board will not decide any aspect of the challenged personnel action other than its connection with the claim of reprisal for whistleblowing. In both types of cases, an administrative judge may grant a stay of the personnel action at issue under appropriate circumstances. Similarly, OSC may, under appropriate circumstances, request that any member of the board order a stay. Needless to say, this authority has been significantly complicated by the lack of any current sitting board members. That said, despite the lack of a board quorum since January 2017, the 60 or so administrative judges at the MSPB continue to hear and adjudicate cases. Of the 5,447 cases administrative judges decided in FY 2018, approximately 1/5 were from VA employees. The MSPB has decided an average of about 180 IRA claims from VA employees each of the past 3 fiscal years, and is on track to decide approximately the same number in FY 2019. In closing, one general trend I do want to note that is not specific to the VA is the increasing complexity of both whistleblower complaints and their adjudication. It is increasingly rare to see a case in which the appellant asserts that he or she made a single disclosure in retaliation for which the agency allegedly just took one personnel action. As OSC can attest, the typical case often involves multiple allegations of several instances of alleged whistleblowing and several alleged retaliatory personnel actions. Because the multi-part test for jurisdiction over and proof of the claims must be applied to each protected disclosure, whistleblower appeals are often difficult and time-consuming to hear and decide. Nevertheless, I believe the MSPB understands that Congress, the executive branch, and the American public are counting on it to be the front lines of sorting through these issues. Accordingly, I know the MSPB aspires to give full and fair consideration to each appeal in accordance with applicable statutes and case law. Again, thank you for the opportunity to appear before you. I'm happy to answer any questions you may have.
Thank you very much, Mr. Levitt. We do have two additional witnesses on the panel today. Mr. Tom Devine, he is the legal director of the Government Accountability Project. Also, we have Ms. Jacqueline Garrick. She's the founder of Whistleblowers of America. They both offered testimony at our June 25th session on the earlier panel, and we brought them back here to allow a more full discussion today. But since they already gave testimony at that time, they won't give additional testimony today. With that, I want to thank each of our witnesses for their testimony. We'll now begin the questioning portion of this hearing, and I'll begin by recognizing myself for 5 minutes of questioning. Dr. Bonsanto, if I could start with you, I appreciate your comments here today, and I think it was made very clear to us by some of the witnesses we heard from earlier, by folks who have reached out to my office, that we have a culture problem at the VA, and I believe you recognized this during the nomination process. After our hearing last month, we heard from whistleblowers about retaliation that's ongoing, and it's clear to me that there still needs to be culture change underway at the VA. So you're 6 months into your job. I'm wondering how you can assess that transition that you said needed to happen and how you will continue to address that as you move forward.
Sir, thank you so much for your question. And I do have to say, coming from the subcommittee as an investigator and now being on the other side of VA, there's definitely been a change in the culture where there's more support from leadership about engaging staff and having conversations regarding retaliation or regarding the importance of engaging staff in addressing concerns. For the first 6 months I've been there, I've seen Secretary Wilkie lead this in conversations with leadership, the importance of customer service, the importance of we engage our veterans and we listen to our veterans, but also engaging our staff and listening to them, and the internal customer service, breaking the silos and having conversations across the administration to improving staff engagement. And I think that's definitely a positive thing. I do have to say, when I came on board too, the Partnership for Public Services, which assesses best places to work in federal government. From 2017 to 2018, VA moved from the bottom third best places to work in government to the top third. And I think that's a positive sign from 2017 to 2018. And I think that's a good sign we're heading in the right direction. Now, there is room for improvement, and I admit to that. And I think the Office of Accountability is a part of that. Change in culture is engaging with stakeholders to improve our processes.
Well, thank you for that. I'm wondering if I could ask the other government witnesses who are here the same question. How would you assess the culture that exists at the VA in terms of being hospitable to whistleblowers, and what needs to be done, what steps need to be taken by the VA to ensure that whistleblowers are listened to, that they're protected?
Sure, I'll take a stab at that. I think it's very important that it obviously starts at the top, so we need good leadership. I think when you have good leadership with people, as I indicated, I have met with Dr. Bonsanto, I've also met with the GC and of course the Secretary, and I have their commitment that they are committed to trying to improve the culture. So I take them at their word. We at OSC have a very extensive relationship with the VA. The VA has the most cases with us, so we obviously have a lot of communication with them. Starts at the head, but also my team meets. We have monthly meetings with them. We also have bi-monthly meetings on the 714 process, which involves discipline. But in addition to leadership, you also have to have education. You have to have people know what the whistleblower laws are. Obviously, once you have the commitment to then abide by the laws. And then finally, you also need accountability. You have to have discipline. You have to have accountability. And this is where OSC comes in as well, to try to assist with this culture change at the VA.
It certainly takes time to change culture. I think that culture was in place for a number of years. A little more than a year ago, we were dealing with the Office of Accountability and Whistleblower Protection by fighting with them about access to documents. So certainly we've come a long way from that time. I think with Dr. Bonsanto's leadership, they're headed in the right direction. It's going to take time, and with whistleblowers, they have to prove to them that it's a place where they feel comfortable coming forward and there would not be adverse actions against them.
So I would just add, along with IG missile, it does take time, and in the same way that culture can be really nebulous to define, right? Looking at an agency, it can be very difficult to change, and there are a lot of layers at the VA, right? And so, my experience from on the Hill was when you had a culture problem at a place, it took a very long time, the sustained effort, along with just commitment from individuals, but to help people really have the confidence that things can work out for the best.
Well, thank you. And Dr. Bonzanto, I'm specifically concerned about whistleblower protection, and that is a charge of your office. I understand that new policies are underway, and you've alluded to those. I just want to get some higher degree of confidence today that the steps are underway for you to improve the protection of these individuals who are so valuable to the process. Could you highlight those steps again for us to make sure that we're going to have greater confidence coming out of this hearing that things are headed in the right direction?
Of course, sir. I do have to say one of the things I was listening through the hearings and also engaging with stakeholders, some of the things that I've learned in our process and meeting with other departments within the executive branch is to improve anonymity and communication with whistleblowers, right? So they understand where they are in the process. And that customer service, like Mr. Kerner said, it's that soft skill. Understand that understand that there might be a fear of retaliation, and giving them confidence in the system and understanding that they're putting their jobs on the line coming forward, and that's something that we're working on improving internally to OAWP. The other thing is empathy. Empathizing with whistleblowers and understanding their perspective, and that's something that those skills have to be developed with my staff, and I'm working on that. So as I'm working on rolling out these policies, it's also improving training for my staff so they understand the importance of this and engaging with leadership throughout the VA, and taking this from the top, and working with the secretary to improve communication and engage the staff. The importance of staff engagement, I think, is where we're at. You have my commitment to that, and that's something that will continue to have these conversations about it. Sure.
Well, thank you. I appreciate your response. I'm not satisfied with where things stand today, but I look forward to continuing to work with you on this, and certainly others will have questions as well. With that, I'd like to turn it over to the ranking member, General Bergman, for 5 minutes of questioning.
Thank you, Mr. Chairman. And as we put up our chart here on the front end, it does violate the KISS principle a little bit from the confusing of the most important people, I think, to understand that how it works are the people who would be your whistleblowers. Whether they may not understand on the front end how protected they are, but if they have confidence and they can see how the system is designed to work for them initially, that'll build their confidence to come forward. So having said that, communications being key, this is Dr. Bonzano and Mr. Missel and Mr. Kerner. I'd like a quick response from each of you on the following. One of the major grievances we hear is that whistleblowers believe that organizations investigating their disclosures do not communicate inter-office, if you will, effectively. What level of communication should a whistleblower expect from your offices, and what barriers exist to meeting the whistleblower's expectations today with respect to that communication?
Sir, I can tell you a barrier that exists in my office is that I can't disclose who the individuals are to the OIG or the OSC without their permission, and if they choose not to, that makes it difficult. If they already reported that they shared information with any one of these entities, that makes it very complicated. We continue investigating, but we might be investigating the same thing without knowing.
Okay.
When a complainant contacts our office, their contact is acknowledged. If they do it through a web submission, a fax, other than a phone call, we send out an acknowledgement that we got it. We also then, and if the case is accepted, we let them know that the case has been accepted. At that point forward, until we're done, due to confidentiality and other reasons, it's really difficult to give an update on where we are. But when the case is closed, meaning either we don't have an allegation or we have finding, we will publish a report, and so the complainant will then be able to see the results of their complaint.
So when I talked about the customer service at OSC, what we're basically talking about is three pillars. One is we want to give accurate information in a timely manner in a polite way. And it's really important that we provide that customer service to people. So when we get contacted, we try to get to people as soon as possible. So we have under the statute, for example, on what you've described as the retaliation section, we have 15 days to get back to people that file with us. We try to do it with under 5 days to make sure that we get back to them right away, that we tell them that we have their case, that they have an assigned investigator or attorney who they can contact. To make sure that they are heard, that we get to their cases with some dispatch, and that we handle the cases in a timely manner. When you ask about barriers, we have not insufficient staff for the cases we have. We have 6,000 new filings roughly every year, and we have a small office of over about 140 full-time employees, including some in field offices. So the barrier is we try to get to their cases as soon as possible, but sometimes we just have a lag and a backlog that takes a while to get to.
Okay, thank you. Dr. Bonzano, OAWP seems to perform functions that are similar to those of OIG and OSC. To what extent can OAWP create a synergy among the organizations in order to best address the whistleblower cases that arise?
Sir, one of the things that's different with the OAWP is that we are within the department. I report directly to the secretary. Part of the law requires us to review, receive, track, and confirm implementation of recommendations from the investigative entities. So that's something that's unique. It's also, within the department, we have one area where we're receiving disclosures. So it's getting the data where we can now have the whistleblower disclosures, recommendations from the IG, OSC, GAO, and the Office of Medical Inspector, and we're pulling that data together to identify opportunities for improvement within the department. And that's something that's very unique in what we're doing in OAWP, and I think that's different than what the other entities do. They give their recommendation, but within VA, we now have the responsibility of ensuring those recommendations are implemented.
Okay, thank you. And Mr. Chairman, I yield back.
Thank you. I'd now like to recognize Ms. Rice for 5 minutes of questioning.
Thank you, Mr. Chairman. Dr. Bonzanto, although the VA has procedures for investigating whistleblower complaints, these procedures have allowed the program office or facility where a whistleblower reported misconduct to conduct the investigation. So GAO even found instances in which managers investigated themselves for misconduct. How do you plan on addressing this issue going forward to ensure independence in the report, in the investigation, and that things are done in an unbiased way?
That for OAWP, we investigate all allegations related to retaliation. We also investigate allegations into senior leadership, poor performance, and management. We do have the authority, similar to SE, to refer cases back to the administration. Part of improving our processes internally is we have developed a questionnaire. We're working on a questionnaire to basically triage these cases to ensure that we're not referring cases back to the program office where a manager who is involved in the case is going to be part of that investigation. Right. So it's improving my internal training for my staff and also creating these templates where they can have a checklist of standard questions to go through to, again, improve anonymity and improve communication and ensure that people who are involved in the allegation are not part of the investigations.
I mean, that's good, because I know that we've heard before about a level of frustration on the part of whistleblowers that it's hard to have an unbiased approach when the person heading the investigation is involved.
Right.
So one of the other, what we heard, and it was really disturbing in the last hearing, how actions taken by the VA against whistleblowers follow them for the rest of their careers and impact their future employment opportunities if they were to leave. But it doesn't seem to be the case for the more senior level employees who retaliate against them. So one issue that I'd be interested to hear yours and anyone else's feedback on, that I think speaks to addressing the cultural issue and holding senior level employees accountable is how relevant information or documentation on instances of whistleblower retaliation or substantiated misconduct is shared across the VA at the leadership and facility levels. And if a senior level employee had been implicated in a whistleblower retaliation disclosure, but no official action had been taken against them for misconduct, is this type of information shared across the VA? And if not, do you think it should be?
Are you, to clarify, you're speaking about if an individual, there's a claim against retaliation that
Yeah.
we substantiate. If there is a recommendation regarding that, we have to report back if the recommendation coming out for disciplinary action regarding retaliation is not followed. We actually have to share that information back. I report directly to the secretary, so leadership is aware if that doesn't happen.
Well, I mean, it just seems that there are more negative. There's a much greater negative impact on the whistleblowers, obviously, than
Right.
the people who retaliate against them. There doesn't seem to be that much accountability at the higher levels in the VA for actions they may take against a whistleblower versus the sometimes career-ending impact it has on the whistleblowers themselves. So how can we make that a more consistent across the board? I mean, the whole culture of the VA starts at the top, and if people in higher positions are not being held accountable when whistleblowers are actually having, a much larger impact, professional and personal impact, how do we address that inconsistency there?
Part of our office, when we're talking about disciplinary action, is to actually track those, and that's part of the data analysis we have to do. So we'll be able to identify those areas where a leader is refusing to take action against someone who's, claiming, who has an substantiated allegation.
So
for
is this something
retaliation.
that you're just starting to try to get information on?
Right, this is something, so I've been in the office for 6 months, so this is something that's important and critical, and the committee's also said that we want to know where these data points are.
So how are you going about compiling that information?
It's through recommendations for disciplinary action. When we give a recommendation for disciplinary action, if those actions are not taken, that's something we have to track within our office.
So you'll obviously be sharing those
Yes,
results with us
yes,
too? Okay,
yes.
thank you very much. Thank you, Mr. Chairman. I yield back.
Thank you. I'd like to recognize Mr. Bost for 5 minutes.
Thank you, Chairman. Dr. Bonzo, as you know, we had issues in my district in Marion, VA, and the alleged whistleblower retaliation. One of the main concerns that the staff has heard about and communicated several times is individual VA employees. So is the communication between your office and individual employees. In your opinion, what's a reasonable expectation of a communications time from your office to disclosure and retaliation complaints? Obviously, not everything reported is going to be have the evidence to back it up in the initial claim. But when this happens and a claim cannot be confirmed, does your office let the VA employee who sent the disclosure or retaliation know so that they know the actions are being taken?
Sir, that's something that we're working internally to improve. As Mr. Kerner said, they're at 5 days, I think, for something. So that's a goal for us to strive to get to. I would say my expectation is that each employee has about, within 7 working days, that we give a response that we received your allegation. One of the things we're also working on is understanding where in that journey, when from blowing the whistle to getting to investigative phase, looking at those touch points. And we also have communicating to my staff in OAWP the importance of informing both the whistleblower, the person that's being investigated, of where they are in the process. One thing that I do want to recognize here and say is that a lot of times employees want to know whether or not disciplinary action was taken. And employees do have a right to privacy. And that's something that we inform them how to go about getting information regarding the case, the person that we're investigating. But I can't, as an entity, we don't disclose to the whistleblower whether or not disciplinary action was taken against the person that they alleged.
That's because they're both employees, therefore
Right.
they're both qualified. Okay.
They both have the right to privacy in the process. Yeah.
Next question I have is actually for all the government witnesses. sometime during these processes, obviously, whenever they want anonymity, sometimes that doesn't happen. Or sometimes you find that the person who has been, had the whistle blown on them, all of a sudden finds out who it was that did that. How do you handle those situations? Each one of you, if I can. Or if it doesn't happen, tell me.
So for MSPB, it's just somewhat inapplicable because we don't conduct investigations in the way that the other three entities do. So it's known when someone files before us who the parties are. The agency will know.
We work very hard to make sure it doesn't happen. Sometimes, though, if it's an office which has a very small number of people, it sometimes is fairly obvious. But we always balance the individual's right to privacy when they do report it to us with the need to go further. We may talk to the individual as well who provided us the information and explain to that person, for us to go forward, these are the steps we're going to have to take just to make sure the person is aware of it. But we try very, very hard to protect the confidentiality of anyone who comes to us who asks to remain confidential, and I believe we do accomplish that.
Yeah, we don't disclose the identities of the person making the claim unless they want us to. Obviously, if there's a need for them, for example, by getting a stay of their personnel action against them, et cetera, sometimes they'll volunteer. But for the most part, we protect people's identities as well. Yeah.
And OAWP, we are committed, we are also protecting whistleblowers. I do have to say, in retaliatory cases, if you choose to remain anonymous, it's very difficult to ask questions regarding retaliation if you're choosing to remain anonymous and disclosing that information. But employees, we do not disclose employees' information unless they choose to.
So one last question, because I've only got less than a minute here, and this is going to be for all three of you. Individual VA employees understand the process of bringing forward a disclosure and retaliation complaint, or do the employees think that all of your offices can handle a complaint? So do they know the process? General Berkman was very clear about the KISS process, which as a non-officer, we understood very clearly. So do you think these employees under this process now understand how to file and truly file the claims?
I'm not confident that's happening. With that being said, we are working, OAWP is working with the OIG and the OSC to develop training regarding whistleblower cases, like whistleblower reporting when you want to make a disclosure.
I don't think they do. That's why I frequently ask VA employees, what do they know about the OIG? Where would they go for a complaint? And it's all levels at VA. It's some of the more senior people don't really understand the relationship between OAWP, OSC, OIG. And that's why we feel so strongly that VA ought to put out a training that we've prepared on when to come to the OIG, when to come to some of the other avenues, and we hope that training gets implemented.
Yes, we work very hard to try to get whistleblowers to know about us. We try to raise our profile. We do press releases. We also count on the agency, the VA, to notify them. We have an agreement with the General Counsel's office at the VA that if there are significant personnel actions, to let them know that OSC exists as a channel. We'd also do trainings. There's some mandatory trainings for supervisors and others about PPPs and prohibited personnel practices. And so we're hoping that employees do know about OSC, and as I said, as we have press releases and other ways to make ourselves known, I think they do. We get a lot of cases from the VA, so we do think a lot of them know about us.
Thank you. Thank you, Mr. Chairman. I apologize for going over time. I yield back.
Thank you. Mr. Rose, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I want to follow up with what you all were just saying about these trainings, because I do feel like we can do this in a bit more of a deliberative and quantitative manner. So first of all, Mr. Missal, you had mentioned that there are trainings that you hope could be happening. Is that, am I correct in saying that?
Correct.
Well, what's going on? Who's saying no to you?
Nobody has said no. We're working through the process. It's a long process. We've put together a training program. VA has a pretty extensive training program for a lot of different areas, including maintaining the confidentiality of documents, protected information, et cetera.
So no one's saying no. What's the timeline for when this happens?
We hope it's sooner than later, but it's been months in the work, and we keep telling another step needs to happen, another step needs to happen.
So do you feel like it could go faster?
Yes, absolutely.
So who do we have to talk to for it to go faster?
Senior leadership at VA.
Can you give us a name?
Talk
to all of them?
Secretary Wilkie?
So we should talk to Secretary Wilkie to urge him for this training to go faster, so people understand who to go to, when to go to them.
That's correct.
Okay, so you can count that we will do that. What about staffing? Whether it's OIG or any of the other offices you all represent, you know, the VA is the second largest department, hundreds of thousands of employees, billions of dollars in budget. Do you all feel like you're adequately staffed to both respond to whistleblowers as well as protect them thereafter? We'll start with you, Dr. Bonsanto.
Currently, sir, I am adequately staffed for what I'm doing.
Okay.
I don't think we're adequately staffed for what our requirements, obligations, and responsibilities are. As VA has grown in tremendous size over the last 5 to 10 years, our office for a long time remained relatively flat.
Okay.
We appreciate the increases Congress has recently given us, and we're getting to a better level, but I don't believe we're adequately
All right, so
staffed.
let's try to go into the details a little bit there. What do you think you do need in order to adequately fulfill your the expectations that we all associate with your the OIG or its other respective responsibilities?
For the next fiscal year, the House has appropriated $222 million for us, which would be an increase from the previous year. Just given we want to grow in a measured, controlled way, we think that would be adequate, but we hope that would be just a series of increases going forward.
Okay. Sir?
Yes, thank you. We're also understaffed, as I alluded to a couple of times. We've had a tremendous growth in cases, and because of that, we have a significant backlog. We have about 2,600 cases that are backlogged.
You have a 2,600 case backlog.
Yes.
And how long is it going to take you to get through that?
Well, it depends on our staffing level, right?
Well, what do you if your staffing level is maintained?
Well, then every year we get about 6,000 new cases, and we resolve about 6,000 new cases. So we have a backlog of 2,600 every year.
So you tell me that that's relatively a 6-month backlog?
Yes, that sounds right.
So walk me through then, from an individual's perspective,
Yes.
right?
Yes.
Whistleblower comes forth,
Yeah.
becomes a part of the backlog.
Correct.
6 months.
Well, I don't know if it takes 6 months because not all cases are the same, right? Some are more fact-specific, some are more intense.
Yeah, but at the aggregate, 6,000 cases in a year, roughly 3,000 backlog. So that's
Yes.
6 months. So what are some of the consequences we've seen of that backlog?
Well, so the consequences are we just don't get to someone's case, which means you might have a very meritorious case of whistleblower retaliation, and unfortunately, by the time our examiner gets to that, weeks or months have gone by, and their frustration level
Can you give us a
goes up.
specific example?
Well, I mean, there's just I don't
You could
have-
pick out of the hat. What's happened where there's been a consequence of that backlog?
So the consequence of that backlog would be that a whistleblower had their case sitting with us and we don't get to it for a while. And a case, I thought you had testimony at the last hearing where one of the witnesses talked about how a case took a couple of years. Now, why does this case take a couple of years? It takes a couple of years sometimes because of discovery, right? You're waiting for documents. But sometimes there's also either changes in staffing or people don't get to cases.
And so what do you need to address this backlog?
More staffing.
How many more?
Well, we currently, as Mr. Missel said, in the House bill, we're at 28 million, which is $1.5 million more than we have now. That would certainly be a big help.
Okay, thank you very much.
Thank you.
I'll recognize Ms. Radewagen for 5 minutes.
Thank you, Mr. Chairman. Mr. Missel, the IG received 35,000 hotline contacts in fiscal year 2018. What percentage of hotline cases are closed without investigation, and what percentage are investigated? And could you please explain how your office decides whether a complaint merits further investigation or should just simply be closed without action?
Of the 35,000 contacts, as I testified, we analyze and evaluate each and every one of those. The number that turn into an OIG investigation is a relatively small percentage. Again, it's a resource issue. We take the matters that we believe are the most significant, most impactful, have the greatest risk to veterans or tax dollars, and so we can only take a relatively small number. A number of the other cases that contacts we get, we may refer over to VA and ask them to take a look at it and report back to us, or just refer it to them. Or a number of the others we may send to another agency, such as OSC, which is more capable of handling it if it's a retaliation case, since Mr. Kerner's office has more authority over retaliation than we do.
Mr. Kerner, of the approximately 2,100 VA cases OSC received last year, how many were disclosure cases, and what percentage of disclosure cases did OSC close without investigation? And how does OSC determine whether a disclosure warrants further investigation?
Yes, so what happens is in terms of determination, we have to meet a legal standard. The legal standard is called substantial likelihood. So when we get a case from someone who files a disclosure, we have 45 days by statute to make this substantial likelihood determination. If it does rise, in the opinion of the investigator or the lawyer, to the standard, then we refer it to the agency, and the agency then assigns it for investigation. We don't actually do the investigation. If it doesn't reach that level, then we close that case. I think in terms of the last cases, let's see, 1 second. So we had approximately 2,100 VA cases. The disclosure cases at VA were about 431, and I don't have the exact, so it's about 39%. I don't have the exact number of how many we closed, but we almost certainly dealt with all 431, so we referred some
And they were
percent.
closed without investigation?
Some of them were, yes. Some of them, if they do not rise to the level of a substantial likelihood, then those cases would be closed, yes. And almost all of them were addressed, certainly for fiscal year 19, we have 431. For fiscal year 18, we had 642 VA disclosure cases. And they would definitely be addressed, certainly at this point, within the 45-day statutory requirement.
Thank you, Mr. Chairman. I yield back the balance of my time.
Thank you very much. I'd now like to recognize Mr. Cisneros for 5 minutes of questioning.
Thank you, Mr. Chairman. Dr. Bonzanto, you had said earlier that the VA definitely needed a culture change, and that really needed to happen at the top, and which I wholeheartedly agree at that. But how is that change? If the secretary is dedicated to this, how are we getting that down to the VA facilities so that they know that a culture change is happening? How is your office making sure that those individuals, the supervisors at the facilities, know that retaliation against whistleblowers is no longer going to be tolerated?
Sir, thanks so much for that question. And this is something, when we speak about internal customer service and the conversations, I can give you the example in my office also that we're doing is the secretary does have town halls with employees. So he's leading from the top and then promoting that, the importance of staff engagement throughout the organization. So something even internal to OAWP, having division calls with my staff, having all hands calls with my staff. Those are things, as an example, that we're doing internally to promote the importance of staff engagement and listening to employees when they have
Yes,
feedback.
but he's talking to your staff.
No, I'm giving you an example. He's taking a leadership, and I'm also doing that in my staff as an example of what we're doing. The other part of it is also the training that we're developing regarding the whistleblower retaliation and why it shouldn't be happening, and what each one of our offices is doing to protect whistleblowers.
Is this training for supervisors, or is it for every employee?
Every employee, sir, by the.
So what
law.
specifically are we doing regarding supervisors to let them know that this treatment is no longer going to be tolerated? I mean, is there anything being done specifically for them, or are they just getting the same training that everybody else is getting?
All employees have the same training, but also supervisors, our office investigates retaliation. That's what we're charged to do in OAWP, and we'll start those cases. There's the accountability.
I get that, but how are we changing the culture, right? I get that you're putting this out to employees and you're letting them know that it's okay to come out and to report the whistleblowers, but how are we letting them know, how are we letting supervisors know that this isn't going to be tolerated anymore, that retaliation, the way that used to be done is going to change? I mean, what is being done different to address supervisors that they need to change the way they're doing business, or business has been done in the past?
That's through training and promoting the offices that we do have here.
I know, but you're saying the training is for everybody, so it's probably a general training that's given to all employees.
Right.
But is there a specific training that's dedicated to supervisors to let them know that when you're a supervisor, you know, like just last week, I had to go to a training that was meant for members of Congress and how I treat my staff. It wasn't an overall, you know, all members, everybody who's employed by the House of Representatives training. What are we doing specifically for supervisors to let them know that business is changing, the way that things used to be done, and tolerating, we're not going to tolerate the way that we treated whistleblowers in the past?
I could find out exactly, and I could take the exact training that's happening for the supervisors regarding retaliation. I know we have the all-employee training for every employee, but as specifically for supervisors, I could take that for the record and get back.
Mr. Missel, you're chopping at the bit there. So.
In 2017, Congress passed the Chris Kirkpatrick law, which requires retaliation and whistleblower training for all supervisors. Our office does that training for all supervisors. We do that on an annual basis.
Has that been effective?
I think it's very effective. It's a very good training program. I recently took it, and so I can personally say I found it very helpful.
Right.
Mr. Centenario, if I could answer some of this.
I was just going to let you, Mr. Devine and Ms. Garrick, I wanted to give you a chance, right? I know it's been like 6 months, but I would love to hear your thoughts and really what you're hearing from those that you represent.
So I think the real issue here, what you're really asking, is about accountability. And when we talk about training, we've talked about training for years and years and years. That is a paper tiger answer, and it's so infuriating because there is no Fear Act training. There has been all kinds of whistleblower training. Mr. Devine does a lot of training. It's online. There's lots of training. The fact that we can show from so many of the people who contact us that they never get responses to their emails. There is no policy in place that explains out any of this. The VA put out a report, a 14-page report with a mnemonic, "We Too Care," instead of a policy statement. That is just so unprofessional. I'm at a loss for words. And the fact that we don't have a good bargaining agreement with the union, we don't have a mentor program that we started that got disbanded. There is a lot of things that the VA was doing, could be doing. We've tried to get regular accountability meetings, scheduled quarterly meetings with the VSOs to go over some of the disclosure issues. But the fact that not a single SES or a single manager who has wasted government money, has put veterans and their care at risk, has not been held accountable, that should be something that this committee should be furious about.
Congressman, we certainly welcome the calls for improved culture and attitude, and we welcome Dr. Bonzano's appointment, and the whistleblower community pledges full support for her. But better attitudes at the top aren't a substitute for results, and the results aren't getting better from our experience, sir. Before the hearing last month, a day before the hearing, one of the key witnesses was fired by the VA. That's intended to send a message. GAP has been working with Office of Special Counsel mediators and attorneys for the last year on trying to resolve 6 whistleblower cases. And despite beyond the call of duty efforts by the Office of Special Counsel. The VA hasn't been willing to resolve any of those cases in a civilized manner. I think if there was any issue that's a good weather vane for whether or not this talk is making it into reality, it's the secret waiting list issue. 5 years ago, that scandal broke, and it horrified the nation, and the VA promised to do much, much better. At last month's hearing, all 3 whistleblowers were disclosing ongoing problems with secret waiting lists. 3 out of the 5 GAP clients that I talked about in my testimony were on secret waiting lists. The problem isn't going away, and it's not surprising why it's not going away. The VA had a very effective corrective action program that was doing outstanding work with hands-on efforts in the medical centers to correct the problem of secret waiting lists. And that was canceled and replaced with a pork barrel contractor, kind of buddy system contractor scheme. If you look at the transition, which has happened within the last 2 years, it's impossible to be optimistic what's happening at the VA.
Mr. Devine, Mr. Devine, I apologize. We're a little bit over on this on his time for questioning.
Yes, sir.
But a couple of us will ask additional questions, and we might get you to allow you to expound upon that a bit. I appreciate your response. With that, I'd like to recognize Mr. Peterson for 5 minutes. Nope. Okay, well, maybe we'll pick up there then, Mr. Devine. We were asking, our government witnesses to gauge a little bit the culture change that needs to happen and the steps that they've outlined. You're not satisfied with that. Would you like to continue or offer any more comments in that vein?
Well, yes, sir. It's the secret waiting list issue that's just eating at us. The VA had a very effective unit. VERC was its acronym, that was going in and working with the hospitals and cleaning up this mess. However, it was replaced, and the Congressionally Chartered Commission on Care applauded their work, recommended giving them more resources and authority so that they could better pursue their mandate. And the VA responded to that recommendation by canceling the work of the VERC, merging it into another unit, which laid off all 127 career employees who were seasoned veteran professionals at solving these problems, and replaced them with an outside contractor under the sleaziest of conditions. The outside contractor had access to inside budget information in order to customize their proposal. The reorganization that brought them into power was instituted without prior congressional authorization, as required by law. The outside contractors were benefiting from federal spending for a study on how to replace federal employees with contractors, which is illegal. The outside contractors were violating federal acquisition regulations by supervising federal employees. And what's happened with this? Well, now instead of having hands-on work at the hospitals, it's a paperwork review where the medical centers certify themselves on an honor system to the outside contractors that they've solved the problems. They've canceled the site visits. They've stopped making progress, and the cost of this has increased from $45 million to $150 million. We've replaced effective corrective action with a buddy system pork barrel scam, Mr. Chairman, and that doesn't leave me feeling very encouraged about the progress at the Veterans Administration.
And then we have, we have the wrongdoers investigating themselves. We have government money that doesn't get properly spent, and the OIG, one of the reports that I cite all the time, is this $11.7 million that went to Caliber while O'Rourke was head of the OAWP. There was no resolve to that. The money doesn't get called back. None of the VBA people that were responsible for that contract, there was no accountability for that. They recommended more training. So that's why I get so frustrated and then we have caps on arbitration. Why are caps at $5,000? Who is going to go through that process when that's the resolve? We have VA employees experiencing cyberbullying. There is no one at the VA that will investigate threats, threats of stalking and actual physical harm to VA employees who are whistleblowers. And The OIG doesn't do it, the VA police doesn't do it, so who does it? There's no accountability for that kind of cyber stalking. And then, why do these things take years? I have filed an OIG complaint on the waste, fraud, and abuse with suicide prevention money at the VA, something this committee has said is its #1 priority, and that case has sat open since 2016, while veterans are dying by suicide. Why aren't we asking, the GAO, I'm sorry, said that $6 million wasn't spent. Well, what happened to unspent money? Who is being held accountable for that?
Well, I appreciate your perspective. It's valuable. I just want to get one more question in before my time's up here, and then I defer to General Bergman for a final question. But Dr. Bonzanto, I want to go back to you, because in the report that your office issued most recently, there's a section called On the Horizon. And so I'm very concerned and eager to learn more about what is just over the horizon for your agency. There are some very fundamental steps: issuing a policy on whistleblower disclosures and OAWP investigations, communicating with whistleblowers, developing standardized training for OAWP investigators, developing specialized investigatory teams, including those trained in whistleblower retaliation matters. Not included in there are very specific timelines. And I heard you mention a date earlier with respect to the training program. I'm very interested in understanding and learning more about the specifics of these things, the timelines for these, so that we can follow the progress and look to hold your agency accountable in the future. Can you provide any of those for us today, or follow up with us with those details?
Yes, sir. So I could speak for the timeline as the policy is rolling out. So we expect by October 1st to actually have our directives involving investigations and what we do, how we do it by October 1st. As for the rest of the requirements in here, by the end of the calendar year, I expect to have all of these implemented. And hopefully we could start measuring some progress and developing the metrics to really give you some type of idea where we are and what our challenges are by the end of this calendar year.
Okay, that is vital. I appreciate that.
Yeah, and
I'd
I'll
like to
keep-
follow up and
yeah.
continue that conversation on those issues. We need to know that information. General Bergman, I'd like to turn it over to you for any final questions.
Thank you, Mr. Chairman. I want to set the record straight here just to make sure I understand. Dr. Bonzanto, Mr. Devine just said that Dr. Agevli was fired the day before the last hearing. I sent a letter asking VA to review under the 714 hold procedures and was advised that she was put on a hold. Can you confirm, do you have the ability to confirm where we are on that, on this one? Or if you can't, if you can take it for the record.
I'll take that one for the record. So.
Okay, yeah, because I just wanted to make sure that we understand where we are in the process with her.
OAWP does have the ability to place holds on actions taken under 714, and that's something we do have in our statute to protect whistleblowers.
Okay, Mr. Kerner, I mean, is there a chance you might know that?
Yes, I believe we have a hold on it.
Okay, well, let's just double check here, because we didn't, again, this is, all of this is recorded, and we want to make sure that we didn't misstate.
Yeah, I checked with the person who does this in our office, and she informs me that we do have a hold.
We do have a hold, okay, so therefore okay, well, anyway, my question is, again, Mr. Kerner, what is, when we talk about training programs and getting people up to speed on the same sheet of music, what is the 2302C certification program? Has VA completed the certification, and what does the certification convey?
Yes, so VA and actually the VAIG as well are currently in the process of recertifying. They had previously been certified under the program, but we're recertifying them now. The 2302C program is a program where OSC has taken on the responsibility to voluntarily have an active role by teaching and educating supervisors and making sure that everybody complies with the retaliation and other legal requirements. So specifically, we act as a certifying entity for agencies, and as part of that role, we work closely with them to ensure that they are meeting all the standards outlined in 2302C to educate and protect whistleblowers and other federal employees. There are roughly 170 agencies, and we have fairly limited resources. So for a lot of them, we don't actually do the training, but we do provide a lot of the slides or other materials for the training, and then we certify when they come back to us and comply with the training program. So that's what we do with that.
Thank you. Mr. Chairman, I yield back.
Well, thank you. Do any of the members have any additional questions before we close? Well, seeing none, I just want to highlight a couple of points here before we close the hearing. First, the subcommittee takes these issues very seriously, and we're going to continue to track the disclosures and the needs of VA whistleblowers. Let's be clear on one fact. Whistleblowers are performing a public service. They are a critical resource, and they need to be protected. The Inspector General will be issuing a report about VA's Office of Accountability and Whistleblower Protection, and a September hearing of this subcommittee will focus on that review, and we await those details, Mr. Missel. We're also awaiting further information from the Office of Accountability and Whistleblower Protection, and as I asked for today, we are very much interested in further details, further policies and procedures and timelines of how we can best track that progress moving forward. Frankly, the testimony today left me wanting more, and so I think further discussions and further hearings are warranted to ensure that things are moving in the right direction. But I remain concerned after a hearing at the end of June where we had 3 witnesses describe some pretty harrowing circumstances that unfolded over many years, individuals who stepped forward just wanting to try to do the right thing. So we have more work to do, and we look forward to talking with you all in that process. So I want to express my appreciation for each of those who appeared here before us today for offering your testimony, your thoughts, your views. We heard a lot of important thoughts on from our government witnesses and from the whistleblower advocates. We thank you for being a part of this again today. And there wasn't always agreement, certainly, but the dialogue is important, and it must continue. Ultimately, we're all working toward the same goal, and that's ensuring that the VA serves our veterans as best it can. And there are certainly ways we all understand that that process can be improved, and whistleblowers are part of that process. I look forward to working with all of you. Dr. Bonzanto, clearly you have an important job ahead of you, and you all do as you move ahead and make sure that things are headed in the right direction, and we stand ready to work with you every step of the way. So it's pivotal that we all come together to improve the protections that exist for whistleblowers and in turn improve services for our veterans. And with that, I'd like to turn it over to Ranking Member Bergman for any closing comments you may have.
Thank you, Mr. Chairman, and very briefly, to echo what the chairman said, we all have a responsibility to protect the whistleblowers, to create a culture in which everyone is held accountable, and we will do our part as the elected oversight part of this, and we're counting on all of you to do the same. So thank you very much for holding the hearing, Mr. Chairman. I really appreciate it.
Well, thank you. Members will have 5 legislative days to revise and extend their remarks and include any extraneous material. And without objection, the subcommittee stands adjourned.